Good analysis now from our legal panel. Chief Legal Analyst Dan Abrams, Preet Bharra, former U.S. Attorney for the Southern District of New York, Asha Rangappa, Assistant Dean at the Yale Jackson School of Global Affairs, also a former FBI Special Agent, and Elizabeth Neumann, who served in the Trump administration as Assistant Secretary for Counterterrorism at the Department of Homeland Security. And Dan, let me begin with you. Just talk about the strength of the indictment to begin.
Well, there are really 2 points here. Number one is they're laying out the intentionality of the conduct. The whole obstruction piece, the lying, the concealing, the hiding, and that he did it on purpose, that he knew what he was doing, why he was doing it. That's the first piece. The second piece is how sensitive the documents were. This is not a case about the illegal retention of classified documents. The 31 counts on those documents are basically saying these were documents that were so sensitive to the national defense, regardless of who classified what, that it is a crime under the Espionage Act to have withheld those documents. And those 2 things together, I think, are what sort of highlight the strength of the case.
Walk through what we know about the documents that he was holding on to.
Yeah, so there are 21 top secret documents, 9 secret documents, and 1 unmarked document. And I think what's most interesting is not the documents they used for the indictment to charge, but the ones they didn't use. Because there were 34 top secret documents that were actually collected during the course of this whole saga. And that means that beyond what we see in the indictment, there was stuff that was potentially even more sensitive that they could not even risk using as evidence because its disclosure could harm.
I want to get to the implications of that in a minute, but first, Preet, let me go to you, former U.S. Attorney here in New York, the Southern District. Talk about the indictment, also the challenges facing the prosecution.
Yeah, so excuse me, further to what Dan said, the indictment's quite strong. As we heard at the top of the program, I think the most damning piece of evidence in the entire case, and I think brings it from a strong case to a very strong case, is the audio tape. You have powerful evidence in the defendant's own words, which comes right into trial very easily.
He knew he had them.
He knew he had them. He says, this is secret information. See, as president, I could have declassified it. Now I can't. The main defense in the case that we have been told was going to be some version of the president didn't really understand. He thought there was a standing order. They could be automatically declassified.
Although they never presented that argument.
They didn't. But this audio tape simultaneously makes out many of the elements of multiple of the crimes and simultaneously rebuts and debunks his defenses. He couldn't declassify telepathically. He couldn't declassify automatically. There was no standing order, and this tape makes that very, very clear.
How about the obstruction portion of the case?
The obstruction portion, I think, is relatively strong. You'll note that the language in the indictment is not necessarily that Donald Trump told a particular lie or Donald Trump filed the false certification, but that he caused those things to happen. And there's a lot of evidence based on the narrative here that Donald Trump had his co-defendant take documents out of out of a storage room when he knew that one of his lawyers was coming to examine the documents for purposes of turning them over to the FBI after a subpoena was issued. So, that story of Donald Trump deliberately, knowing that a lawyer was coming to look at the documents, having them removed with a subpoena pending, I think is very devastating.
Elizabeth, the president's treatment, former president's treatment of the declassified documents is something you're familiar with inside the Trump administration.
Yeah, that's right. I found the indictment to be a really vivid picture for the American public of what the national security community dealt with for 4 years when he was president. He had a blatant disregard, just did not care to follow the rules. And not only did he not protect our country's most sensitive secrets, that's not protecting American lives, because you have military and intelligence community personnel that are now put at risk. You have assets, our foreign allies' information is put at risk. So all of these things are leading to, if any of those documents have been accessed by
how possible would that be down at Mar-a-Lago?
Well, the indictment said 10,000 people that went through, tens of thousands, I think it actually said, that went through it at various times where the boxes were easily accessible. And if you're a foreign intelligence agency, you know that Mar-a-Lago is a great target, and you're probably trying to figure out what might be there. So we don't know, or hopefully the investigation and there are things not in the public domain, hopefully we're finding out what might have been leaked. But this causes people to die. Like, this is very serious, top secret, special access programs. When they fall into the wrong hands, people die, and the United States security is deeply compromised.
Dan, let's talk about how this case is likely to play out. One of the first things we found out, it's been assigned to this judge who had jurisdiction over the Trump case earlier.
Yeah, Aileen Cannon. We don't know if she's going to actually have the trial itself. We know she's going to have the early portion of this case.
What would prevent her from having the trial?
Well, look, they're going to determine down the road who the judge is going to be in the case. But for now, she's handling the first hearing in the case. And look, and I think that's a good thing. It's a good thing because at least the focus won't be on who the judge is, right? Because in a lot of these cases, you see Donald Trump saying, this judge is biased against me. There is no way he can argue this judge is biased against him. He appointed this judge. This judge had a very favorable ruling to him that was ultimately overruled by the appellate court. And these initial proceedings, I don't think are going to make or break the case either. It's going to be interesting to see what are the early motions that they make. We know already what some of the legal arguments that they're going to make are, but what are they going to try and keep out of evidence? What are they going to say shouldn't be admitted, et cetera? That's going to be interesting in the early days of the case.
Preet, one thing this judge could control is the timing of the case. I've read a lot of analysts saying that the fact that Aileen Cannon has now been put in charge of the case, at least initially, guarantees, or all but guarantees, that this case will not be go to trial before the 2024 election.
Yeah, look, I mean, one point further to what Dan said about whether or not she will continue to be on the case, I imagine that the government is thinking about making a formal recusal motion, not on the ground that she was appointed by Donald Trump, but on the ground that earlier on in the case, she ruled very favorably, arguably in a biased fashion, in favor of Donald Trump in a way that was roundly rejected by the appellate court in language that was quite strong.
They won't win that.
Maybe.
Yeah.
But you know.
Don't you think it would be a mistake, though, for them to make that motion in early days to already try and get the judge dismissed?
I don't know. That earlier decision was remarkably bad.
Yeah.
We're on television. We talk about these cases and matters all the time. There was pretty much unanimity among legal experts at how bad that earlier decision was. So that's maybe a basis for recusal. They might wait to see how some of these motions play out and see what kinds of decisions she makes. It may be the case, and I'm guessing here, maybe she doesn't want to preside over this case. maybe she's had enough of her time in the spotlight on these kinds of things. But if Donald Trump himself and his team want the trial to happen quickly in any of these venues, either in the Manhattan DA's office case or the federal case or perhaps in the Georgia case, it can happen quickly. Ted Stevens, you may recall, many years ago, fought for and received a quick, speedy trial before an election. I think it's in his political interest, Donald Trump's political interest, not to have a speedy trial, and he probably won't get one.
Asha, one of the things we've heard from the former president's defenders is that there's a double standard of justice going on here. Address how this is distinguishable from the cases, say, of Mike Pence and President Biden.
Yeah, I think that's the piece that the indictment really spells out, is the willful and deliberate. I mean, it's quite astonishing. The orders that were being given to his body man to move these, to conceal them, to actually conceal these documents from his own lawyers, implying, suggesting, hinting that maybe they should be destroyed or plucked out. These are all his own words that he is using. There's audio tape of him knowing that this is classified information. There are text messages. The receipts are here that this is conduct that I don't think Mike Pence or Joe Biden engaged in any way at all.
Turn back the clock. Go back to 2021. Had the National Archives gone to Donald Trump, had he done a thorough search and turned over all the documents in his possession at Mar-a-Lago and Bedminster, although they were at Bedminster later, would we be sitting here today?
Absolutely not.
No.
Absolutely not. And that's why I think it's less important when people talk about, well, there were documents in a bathroom, well, there were documents in a ballroom. Okay, that's important and interesting, et cetera, but it's really not as significant, I think, to the legal charges here. The legal charges here are not that, it was just a mess, et cetera. It's that the effort to conceal it and hide it was one of the key elements to the crime. And number two is the fact that those documents that he made an effort to hide and conceal were so sensitive. Those two things together, I think, are what led us to where we are today. Because, in my view, you needed both. You should not have charged if the documents were just random sort of classified documents, but not particularly sensitive ones, because you're talking about the former president. Here you have both.
You agree with that?
Yeah, look, it is not a part of the element of the crime that particular documents be even classified, much less, super sensitive classified information. But we talk about a thing, if you try cases of jury appeal, and the significance and the dangerousness of the conduct plays into how a jury thinks about a case, which is why the prosecutors in the indictment, not necessary at all, important at trial, recite words from Donald Trump's own mouth, not of a criminal nature, but in 2016 during the campaign, how seriously he will take classification rules and laws.
And that's the final thing I want to get to, Elizabeth. Given all this, Elizabeth, if Donald Trump is indeed elected president of the United States again, what are the national security implications?
I have a hard time going there. It was so traumatic for 4 years trying to figure out how to keep the country safe from a man who had this, he just didn't care. He did not care to keep our country's secrets safe. He did not care that it was putting people at risk. And the idea that we would do 4 more years of that, and by the way, they've actually learned how to use the tools of government now. It will be much more consequential and a very serious threat for the safety and security of the country.
Thank you all very much.